think the first thing to think about is what states you're willing to take clients from, what state law, which really means what state laws are you willing to litigate. So in the employment space, when you're talking about misclassification, for example, there are certain states that have an ABC test, which is much more employee friendly than the more classic control tests in many other states. And so one decision that you might make is to just take clients from ABC states. And you do see that a lot currently. In terms of kind of the arbitration side of things, something to consider is what the filing fees are going to be. The filing fees are the same as in court in some sense, but in court you can file a multi-plaintiff complaint. So if you have 200 clients, you can file once and pay 200 whatever filing fee. In arbitration, because they are actually individual, that's going to be 200 filing fees. But the other thing to consider is if you're in California, there's a rule that arbitration companies are required to waive the fees for any employee whose income falls within 300% of the federal poverty line. So if you limit yourself to cases in California now, you get the ABC test, you get the Private Attorney General Act, and you get this fee waiver requirement. And I can tell you, at least for cases against some of the gig companies like Lyft, for example, a huge proportion of the clients qualify for the fees to be waived.
How about logistics and other resources firms need to be thinking about if they want to get into this kind of work?
I think it's really important that firms look at technology, not just in terms of its time-saving benefits, although automation and things like that have the potential to really, really make it more cost-effective, efficient to litigate. But also, it increasingly seems to be what clients want. If you imagine particularly these gig economy cases where the worker is interacting with the company mostly through a phone, if not exclusively through a phone app. And many times their expectations of their lawyers is that same convenience and electronic aspect of how you're doing things. And so, I'd recommend that firms that are considering it look into what technologies they can use, not only to make it easier for them to litigate, but to make things easier on the clients.
We deal with that a lot, especially for the driver companies. Text messages, right? It seems to be the most sort of powerful thing because that's what they're doing all day, every day. We don't even know if they look at their emails. So that's a very interesting point.